This lawsuit was started years ago by 5 low-wealth counties in North Carolina who essentially contended that their students were being deprived of a sound basic education by virtue of the funding formula that the General Assembly had adopted. And under the North Carolina law, the county is responsible for about 20% of the educational funding. And their argument was, we're poor counties, we can't provide the kind of quality education that a Wake County or an Orange County can because of the funding.
I was going into 9th grade when it started, or I guess I was in 9th grade when it started, the case started. And at the time, you know, we really didn't know the issue that well. What we knew is that there felt like there were things that we should have had at our schools that were commonplace: science labs, equipment, photocopies, computers, things like that, that just weren't there. One other interesting thing that happened, and I remember this being a huge, what we thought was a great advantage for us, is that we got to watch high school students in Chapel Hill do labs through a remote connection. That was how we did our labs. That was a big deal for us. That was, hey, we at least get to see what goes on in these labs. We don't have to just read about them. And then when I tell people outside of the schools, you know, outside of our school system, who thought that was a great thing, they sort of say, wow, that sort of sets off in their mind the differences, that we're watching kids in our state do labs because they have labs over an internet connection because we don't have the labs.
So we got into the case, and what had happened was the case went before Judge Morris Braswell, who is one of the best Superior Court judges we ever had. He said, and the state made a motion to dismiss, saying that the complaint, there was no right, so the complaint failed to state a claim that the courts could recognize. Judge Braswell overruled him and said, yes, there is a right to a public education, and this suit may go forward. Well, it went over to the Court of Appeals, and they reversed Judge Braswell. And what they said is, it's true the Constitution has a right to a public education, but all that means is the state has to have a school system. It doesn't say anything about the qualitative aspect of it. In other words, are they actually learning anything? It's just, you got to have a building there. It's got to be open some regular times, and there should be a teacher there, I guess. But it came to us, and the issue for us, first issue was, is there a constitutional right? And if so, is there a substantive aspect to it? In other words, in order to meet that need, must the state's children be given an opportunity to really learn and to go ahead to college or into professions and so on? And then the second part was, if there is, do all these schools have to be funded the same?
Well, that was when the North Carolina Supreme Court ruled that every student under the North Carolina Constitution has an opportunity for a sound basic education. Now, I would note that I dissented in part because the majority and Chief Justice Mitchell, who wrote the opinion, were absolutely determined that we were not going to go down an equal funding path with the decision. And even though the plaintiffs had argued that under the Equal Opportunity Clause in the state constitution, that it didn't mean that a low-wealth county was entitled to the same level of funding per student that a high-wealth county did. And so it ended up turning on this sort of esoteric standard of an opportunity for a sound basic education.
Leandro's often been referred to as an educational funding case. And we said at least 3 times in there, no, it's not. It's an educational achievement case. We're not measuring input, and we said this specifically, it's output that matters. What are the kids coming out with? Now, it's no secret to any of us, you got to have money to run schools, but we did not want to get off on the chasing the notion of everybody has to have equal funding. And here's what we said that when I waxed eloquent here. It says, we answer the question in the affirmative and conclude that the right to education provided in the state constitution is a right to a sound basic education, period. An education that does not serve the purpose of preparing students to participate and compete in society in which they live and work is devoid of substance and constitutionally inadequate.
The Supreme Court had answered it, but they didn't answer it specifically. Who in the hell is responsible? Who is responsible? This is a constitutional right. This isn't a court-created right. The founders of our Constitution, 1868, wrote it in there after the Civil War. The state has got to be responsible because it's under our Constitution.
Well, there really wasn't a constitutionally based definition. I think you had a variety of statutes that the General Assembly had passed over the years, talking in a very comprehensive way about educational standards and testing and the like. So this was the first time really that it had been articulated.
The Leandro ruling is very similar to existing federal government statutes, so with Public Law 94-142, where every child is entitled to a free and appropriate public education. And I think that for the state of North Carolina, I think they were trying to hit on pretty much the same type of issue when the Leandro ruling basically says each child needs to have a sound basic education. The thing that I think that we've been missing with the Leandro ruling and with Public Law 94-142 and most of these type of decisions is how we interpret each, and because I think that the school system for 40, 50 years has concentrated on all, and all is not appropriate according to the Leandro ruling and according to Public Law 94-142. That's what I view it as, is that we want to look at see how all 8th graders are going to learn and how all 12th graders are going to graduate, when really what the ruling is trying to say is that we need to follow each child, and what do we have to do to make sure that they are receiving the best education that they can get.
Well, I think there's a lot of different impacts. Certainly the money part of it is tangible in a way, in the sense that there is now a science wing at our high school with brand new labs that came from some of the money that was set aside for Leandro, the construction funds. And that is something that you can point to and say that's something we didn't have. I think it's just really more the recognition of the issue, and that's something that has always been important to me, is to say we need to start talking about what it means to get a sound basic education, which I don't think anyone was talking about before the Leandro case. And in these times especially, it's very relevant. I mean, with the unemployment rate what it is, the folks that don't have the right education and don't have the ability to get that education are going to fall behind. And I think we have sort of an obligation. So I think that's what Leandro said, is there is a constitutional obligation, just like any other constitutional obligation. We have to protect it and make sure it's enforced. And that's something I don't think was talked about before Leandro.
What happens sometimes in litigation is that where a case starts isn't necessarily where it ends up.